happy to see a lot of familiar faces here. For those who I do not know, I'm Natalie Thompson, past president of the Austin Lawyers chapter, and it has been my privilege to get to help out planning this great conference. Thanks to everybody for coming and to all the folks who contributed to a really wonderful event last night and to today's panels. Where we get to, all finish up our CLEs for the year, hopefully. So this panel is going to be focusing on educational freedom and talking about school choice, parental rights, and all of the interaction that there is in that area. There's been lots of movement in the area of educational freedom, especially here in Texas, where the legislature just passed a significant educational choice bill. And so this panel is going to talk about that, along with venturing answers to questions like how much say do parents have on what happens in the public school classroom? How can public schools respond to changes and innovation in order to provide quality education, respect parental rights, and still fit within various constitutional doctrines? And then when it comes to constitutional doctrines, is the framework going to be the same depending on whether it's a charter school or a traditional public school? So this panel is going to address these questions and more and really delve into the landscape here in Texas and on the national stage. Moderating the panel this morning is Judge Jeremy Kernodle of the Eastern District of Texas. We're so grateful that Judge Kernodle made the trip down from Tyler, where he now sits. He's been there since he was nominated by President Trump and confirmed in 2018. When I first met Judge Kernodle around 2014, I was right off a clerkship starting out at a big law firm in Dallas, and Judge Kernodle was a partner at Haynes and Boone. But more importantly to me and to my cohort of young lawyers starting out there in Dallas at the time, he was the president of the Dallas chapter of the Federalist Society. So he brought us into that chapter, welcomed us, and showed us how to practice law as a successful partner at a big Dallas law firm, practicing with excellence and with integrity. His example is one that I always strive to emulate going into the practice of law. Judge Kernodle graduated from Harding University and then to Vanderbilt Law School. He served as a law clerk to Judge Choflat. Did I pronounce that correctly?
You did, yeah.
Choflat on the 11th Circuit. He also has served in OLC out in D.C. and was an associate at Covington and Burling in D.C. Thankfully, he made his way back to Texas eventually, and here we are today. Thank you, Judge.
Okay, thank you very much. Well, we have a lot to cover, so I'm going to try to do our bios quickly and efficiently. I will start with Arif to my immediate left. Arif Panju serves as a managing attorney with the Institute for Justice. He leads IJ's Texas's office while also litigating cutting-edge constitutional cases protecting property rights, economic liberty, free speech, and educational choice. Arif's work has resulted in court victories nationwide. In the United States Supreme Court, he second chaired Carson versus Macon, in which the court held that states violate the free exercise clause when they exclude religious educational options from school choice programs. He's a graduate of SMU Law School and the current president of the Federalist Society's Austin Lawyers chapter. To Arif's left is David DeMatthews. Mr. DeMatthews is the W.K. Kellogg Endowed Professor of Education Leadership here at UT, where he holds an appointment in special education and directs the Cooperative Superintendency Program. David began his career in education working as a teacher, campus leader, and district administrator in the Baltimore City Public Schools and the District of Columbia Public Schools. So you have seen it all. David has also examined the impact of school choice policies on public schools, and we'll hear about that shortly, as well as the impact on historically marginalized students. Next is Ryan Bangert. Ryan serves as Senior Vice President for Strategic Initiatives and Special Counsel to the President at Alliance Defending Freedom. Ryan oversees ADF's government affairs and corporate engagement teams, as well as the Blackstone Legal Fellowship Program, which many of you, I'm sure, have already been a part of or are hoping to be a part of. Before joining ADF, Ryan served as Deputy First Assistant Attorney General and Deputy for Legal Counsel in the Office of the Texas Attorney General. In those roles, Ryan oversaw the state's Special Litigation Unit, which handled critical litigation against the federal government and oversaw multiple divisions within that office. Ryan has also served as Deputy for Civil Litigation for then Missouri Attorney General Josh Hawley and was a litigation partner at Baker Botts. Ryan earned his JD from SMU, where he was a Hatton Sumner Scholar and graduated first in his class. And then last but not least is Becky Ricketts, a senior counsel at the Beckett Fund for Religious Liberty. Becky litigates First Amendment claims in federal courts across the country. Before joining Beckett, Becky served as an assistant U.S. attorney for the Northern District of Texas, where she prosecuted a wide range of federal offenses and served as the human trafficking coordinator for the district. Before that, Becky practiced appellate and constitutional law at Gibson Dunn, and she has served as a law clerk to Justice Clarence Thomas, Judge Jose Cabranes of the Second Circuit, and Judge Richard Sullivan, then of the Southern District of New York. Becky earned her JD from Yale, where she was a book reviews and features editor at the Yale Law Journal, and her BA with high honors from here at UT. Okay, so as I mentioned, we have a lot to cover, but I'm thinking about it in 4 different buckets. First, we're going to look at what's happening and has happened recently in Texas with Texas's recently enacted school choice program. That'll primarily be Arif and David kind of giving us differing viewpoints on that. Then we're going to shift gears and talk about the constitutional challenges to school choice laws. We'll hear from Ryan and Arif on those issues. And then the requirements to provide parental choice in public schools after the Supreme Court's recent decision in Mahmoud. Becky will cover that for us. And then hopefully if we have time, I'll ask some general questions about the future of educational freedom from each of our panelists. And then hopefully we'll have some time at the end for questions. So if you think of a question while we're going through, then keep it in mind and I'll try to get to you at the end. Okay, so let's start with what's happening and has happened recently in Texas. Texas only recently joined other states by enacting a school choice program. Many of you have heard of Senate Bill 2, which was signed into law in May of this year. It creates an education savings account for eligible families. The program is set to launch next fall in 2026 and will allow families to use taxpayer money for private school tuition, homeschooling expenses, and other educational costs. So let's hear first from you, Arif. What fueled the adoption of educational choice programs nationally over the last several years, including in Texas?
Thank you, Judge. These 3 big picture things that happened nationally that just lined up beautifully in the last couple of years for what Texas had been attempting to do for many years, and that's to get school choice passed. Not out of the Senate, which happens all the time. Senator Mays Middleton was here last night, and he's a great champion for school choice, but the House would always stifle passage of the program. So first things first, what do we mean by school choice? The early school choice programs that hit the books, one of the first modern ones, 1990, city of Milwaukee, a year before IJ opens its doors. What's going on there? What we mean at IJ when we reference school choice is that every parent, regardless of means or what zip code they live in, deserve the freedom to decide how and where their children are educated. The state's going to get involved in educating children. That's it. And so the big picture thing, the first one, is that that's pretty popular with parents. They like freedom and they love their kids. And when those 2 things get together and they get to use a school choice program, they realize that they can do a lot of good in their kids' lives. And so it was slow going in the early days in the 1990s with city-based programs like Milwaukee's or Cleveland's. But the unions were attacking those anyways, even though these were small, narrow programs. And it was only after the Cleveland program makes its way to the U.S. Supreme Court in 2002, and probably one of the most, if not the most important education case since Brown v. Board of Education, Zellman v. Simmons-Harris, where the Supreme Court rejected the idea that merely picking a religious school somehow violates the Establishment Clause because the government is supporting an education program. The Supreme Court held that this is an individual aid program, not institutional aid. It's aid to families. And if they want to make an independent decision and the government doesn't put a thumb on the scale one way or another regarding what option they pick, there's nothing wrong with that. It fully complies with the Establishment Clause. That opens things up throughout the 2000s, and we get to the 20-teens, and you've got programs that that look a little bit less like the early ones. The early ones were vouchers, a straight one-to-one kind of check that's cut from the government based on the choice that a parent makes. But by the time you get to the 20-teens, and the innovation that Texas gets to look at is important here. Education savings accounts come online, and they're very popular. They allow parents to have a menu of options to pick what they want to educate their kids, whether it's tuition, homeschool curriculum, special needs therapies. And these things catch on like wildfire. So by the time we get to the 2020s, we've got today, for example, a very popular movement at this point. 82 programs around the country, 35 states, for what began just a little bit over 30 years ago, now have school choice programs, including the Washington, D.C. program and Puerto Rico's. And almost 20% of states now have gone full universal. Every child in that state is eligible for a school choice program. So that's the first big picture thing. The second is COVID. COVID did a lot of things, but one thing it did is lift the veil for a critical amount of parents. I mean, it was on scale. Everyone got to see what was going on with the assigned educational option that their kids were being dropped off at every morning. And many people didn't like what they saw. They also didn't like the response that the districts had, and perhaps that's Randy Weingarten and company, unintentionally draining their credibility, but that helped the school choice movement also during COVID. But in my view, the most important thing during COVID is the entrepreneurship and the embrace by parents of their kids' education and just trying things outside the public education system. Homeschooling, co-ops, micro-schools. I mean, that catches like wildfire. So by the time we get to 2023 in Texas, things are looking good and you have the groundswell of support.
So tell us about Texas. What does SB 2 say and do, and what did it take for the Texas legislature to get that across?
So SB 2 creates an education savings account, and it created the biggest day one program in the country. Thanks to Governor Abbott, really just being resilient in 2023 with 4 special sessions trying to push this through and eventually saying, all right, guys, I'm going to go out to rural Texas and primary you guys if you keep opposing school choice. The House was killing every Senate bill that would come through, not allow floor votes, and behind the scenes, just doing everything that you do at the legislature to slow down or kill bills. And they appropriated $1 billion. So after all the primaries take place, the composition of the House radically changes, and school choice has the votes necessary. So in 2025, the bill that's introduced, Senate Bill 2, creates the largest day one program. The appropriation is $1 billion. That's about 100,000 education savings accounts. And just to put it into a national context, this is not just an epic moment for school choice. When Governor Abbott's signature hit SB 2 at the governor's mansion just down the road here, a full 50% of American children became eligible for a school choice program in this country. So that's an epochal moment. That's a shift, a radical revolution in education akin to the modern school movement, the rise of that in the 1800s. And now, with Texas was the prize. And now that we're seeing the incredible momentum and just wide acceptance for school choice, I think we can look forward to more of that happening.
And I don't know if we covered this before in our discussions, but what do you have to do to qualify to get some of the money from the state through the SB 2 program?
So everyone's eligible in Texas. But of course, when there's an appropriation that is not the amount that can fund the entire state, not everyone is going to opt out of a public education system. Most people won't. They're happy with their schools. But you just need to be a child eligible for K through 12 education. If there is more demand than supply, money-wise, the priority goes to low-income children and special needs children, middle income, and then everyone else. And that's pretty much par for the course across the spectrum in the U.S. And the headwinds that usually try to stifle these programs at a legislature, which weren't working at this point anymore in 2025, were that the program's just not accountable. Look, we're not controlling these schools. Well, the parents can vote with their feet. They now have an education savings account, including all the parents that could never write a check or live in a zip code where there's good public schools. And that is the accountability, the parental accountability. And the other headwind is simply that you defund the public school system. And that was another headwind that fell apart. No one says that you're going to defund Walmart if you go shop for groceries at H-E-B, or that if you have a Pell Grant, you're defunding the community college because you're deciding to go to St. Edward's University here on the hilltop just south of downtown. And so those things, those types of arguments didn't take hold, and the momentum that was brought to bear at the Texas Capitol. And frankly, it was a huge effort by the governor, the governor's office, state lawmakers, and activists on the ground that had worked for about 15 years, some of them here, because I've seen them, that were there from the very beginning all the way to the end. So it's a great victory for children and for parents in particular.
Okay, so David, I want to ask this question of you. As Arif mentioned, many of the opponents of the Texas program and other similar programs are very concerned about what school choice will do to the public schools, diverting essential funding away from them. And then, of course, supporters, as we've heard from Arif, argue that the program provides families with more choices and encourages competition among schools, which would hopefully improve quality for everyone. So let me hear from you on your response to those concerns and claims.
Sure. Thank you. So I think there's a lot of concerns, and I think choice for a lot of parents in Texas is really more about marketing and selling a policy than actually what happens, especially for low-income families. And private schools don't have to serve them, so private schools are the ones really that are choosing which kids go to their schools. But what I just want to start with, what really matters here is, I think probably everybody can agree with this, the state has a responsibility to make sure that all students, all children are well educated and taken care of. And this state, this legislature, prior legislatures, they've consistently failed in both the public system to making sure that happens. And I want to point out just a couple of things. I want to focus on students with disabilities. I want to talk a little bit about mental health. In our public system, since they, no matter what, whether a child's accepted into a voucher program or into a private school or not, public schools have to provide these services. And so our counselor to student ratio in Texas is 400 to 1. Our teen suicide rate is 12 in 100,000. 22% of Texas students considered suicide in the last year. 2/3 of kids report major depression and not getting any care from a mental health provider. 49 kids have died in our child foster system in Texas. And our legislature has had a $32.7 billion budget surplus in 2023 and a $23.8 billion budget surplus in 2025. Schools are in a pivotal position, public schools are in a pivotal position to help address these issues. The legislature, the governor, they're also in a pivotal position. Public schools are the one place potentially that has to have these positions, and our legislature has failed, but they have still managed to set aside $1 billion for an optional program that is not necessary while we have a significant crisis in our state affecting children across the board. And so I just want to start with that and then talk a little bit more about the research on voucher programs in other states. And so the best available evidence on large scale voucher programs, right? So in Milwaukee in the 1990s, we started really small in the city of Milwaukee with urban schools, and there's very specific measures for who qualifies, how many kids that use a voucher in a private school can attend there. Students with disabilities were excluded, which I would say, is going to be a continued issue through the history of vouchers and education savings accounts from those initial programs. And they got really mixed results, really contentious results. Researchers come in from Harvard, and they're debating about research methodologies and whether or not there are statistical significant findings. But when we fast forward and we look at Louisiana, we look at Indiana, Ohio, DC, where there are larger voucher programs, where there's a larger portion of students who are able to enter into this marketplace, we see some of the worst outcomes in any education policy we've ever seen before. And so this is a real concern. The Fordham Institute has conducted some of this research, pointing it out. Betsy DeVos, a very powerful advocate for vouchers, has said maybe there's some issues with design. And I think there is issues with design, and I think there's still issues in design here in Texas with SB2. Relatedly, this idea that markets work for us
Let me
so
just
well.
interrupt real quick on, you said the outcomes are really bad in those programs. Is that outcomes, looking at the outcomes of the students who participate in the voucher programs, or the public schools, or both?
Sure. So what the bigger studies have done is they try to draw as much as possible apples to apples comparison. So students who were eligible for a voucher but did not end up going to a voucher school. So comparing those students with students who were eligible who went to a private school, and what researchers find, and controlling statistically for race, family income, a variety of other geographic factors that researchers have access to in these large quantitative data sets. They find when you make these comparisons, these as much as possible apples to apples comparisons, students do really poorly in voucher programs over time. Some of the reason for this is there's not a lot of control on quality. And so something SB2 did was require that the private schools that receive students have to be an accredited private school. In some of these other designs, the quality of those schools are not the same. There's not the same kind of standard. And so design does matter when it comes to vouchers. I think there's a whole bunch of other failed assumptions around what vouchers do, but design does matter. And so we've seen in some of the other states really poor design choices that led to really predictable failures that then you get Betsy DeVos and the Fordham Institute saying, hey, like there needs to be more thinking about how we design these programs. So the evidence with those studies are really clear, really problematic, and they kind of undermine, and they fit right in actually with kind of critiques or general assumptions of how markets operate. There's just a number of challenges that make schooling very different than having a high quality cell phone and having Apple and Samsung kind of compete in an open market. There's high transaction costs. So the idea that vouchers are for everyone is a lie if you have low-income families and the voucher doesn't cover the full cost. If a voucher doesn't have some sort of progressive scale that allows a student to go to one of Dallas's most expensive private schools that cost $50,000 with a $10,000 voucher, that's not free entry into the market for that child. That's really kind of cutting that family out and just giving kind of voucher to the families that already have enough money. And so I think it's really unpopular with families once they kind of figure out that they can't go anywhere with that particular voucher. If they have a child with a disability, if they have a child with a disciplinary background, and say the public school's not doing a good job, and I'll be honest with you all, there's a lot of problems in public schools around special ed and serving kids with mental health problems. A $10,000 voucher is not going to incentivize a private school or a new private school to open up to provide intensive services that could cost $20,000, $30,000, $40,000, $50,000 a year to kind of provide supports to those students. And so I think the idea that this is a competitive market is not entirely true. It violates a lot of the kind of classical assumptions of free markets. And I think those are particular concerns for me. I also do think it will, in the long term, divert funds from public education. I would agree in the short term, SB2 is not going to divert much money from public schools. So there's 100,000 roughly potential voucher users with $1 billion if the voucher's about $10,000 per student. TEA, the state agency, estimates maybe there's 25,000 open seats in private schools, assuming every private school wants to admit students. What happens to that other 75%? So basically, there's no space, and so what we see happen, and we've seen this happen in other states as well. Virtually all the students who are already in private school are getting access to the voucher because there's not enough new seats in private schools to accommodate families that might want choice, that might want to leave the system. We've seen that in other states. I would say the legislature did this by design only because it's such a predictable problem. They could have dedicated that $1 billion to say, regardless of what that private school tuition is, we're going to cover it if that private school is willing to admit that child. I would say that would create actual choice. What they did instead, knowing that there's not that many seats available, they basically just turned around and gave tax money back to the families that are already enrolling their children in private school. And I'll stop right there with my frustration point is we're giving money away now to families already sending their kids to private school. That's all good and well, but not when we are failing our kids in our foster care system, in special education, not having counselors in hundreds of Texas schools. That, to me, we can't have a pet policy in a state that says it's run by fiscal conservatives that are ignoring the needs of our most vulnerable children just to support a policy that's not necessary.
Let me ask about, it doesn't sound like many states have had this program long enough to maybe study whether this is true, but I would assume that over time you would have more options become available. So it's true that $10,000 today may not get you anywhere in the city of Austin, but over time I would guess that there would be micro schools and other schools that might be created that would accommodate students at that cost. Has anybody looked at that, whether that's happened in other states?
So the challenge with micro schools, so the way that...
Well, any school
Sure.
that can, not every school has to have a football stadium and all that. So if
Sure.
you could offer
Yeah.
education that satisfies the requirements that we all care about at $10,000. And, we have friends in Tyler that have been kind of waiting for this program to become law because they have some ideas about how to create schools at that cost. Have other states, have you seen that happen in other states?
The larger scale programs are relatively new, right? So when we started with vouchers in the United States in the 1990s, they were very, very small. And we're seeing them grow. And as Arif said, right, Texas, this is the first kind of day one. It's the largest voucher program in the country. I would say, though, as long as the voucher, and what we see in states that have been doing it longer is just the same thing. It's 75–80% of the students who are enrolled, who are using an ed savings account or voucher, whatever you want to call it, they were in private school before the bill, and they're staying in. And the majority of low-income families are not really benefiting, especially across the state. Context really matters, though. States are different. Texas is a geographically large state with vast rural areas where there's very little private school. There's not really a lot of students around to kind of have a lot of innovative different programs. But the key thing that I just want to hammer in on, whether it's micro schools or people getting excited about things, there's some great private schools in Texas that serve students with disabilities. The kids who are the most vulnerable in our society, they have the greatest needs, and those needs cost because we have to pay for therapists and special programs. And so as long as we're not adequately funding a program to ensure that a private school or a public school can hire counselors, have therapies, have technology resources, the students who are at the margins are going to be vulnerable. And I don't see how vouchers can solve that particular problem. And so we have a system. We need to focus on that system from my perspective. We have not seen true education markets pick up anywhere where everybody's free to enter, where there's very low transactional costs, where there's not barriers to entry into the market. And so those things concern me primarily for the most vulnerable kids. And I will say, vouchers do work quite well for some kids that they needed something different. They didn't need the big Texas football experience. They needed something else. But on the whole, that's where the concern is and where we're not seeing results.
Okay, Arif or anybody else want to respond to?
Just quick bullet points. I think the joy of school choice is it treats individual kids as individuals, not as mere funding conduits for a system, which we deal with a lot in litigation. Like, well, the kids are actually the customers here. And from that lens, I think you can see that it's very popular and it's working. And the reason I know this is because when we're defending these programs in state after state, like let's say like Utah right now, that program was oversubscribed at like 3x. Tennessee's new universal program that Governor Lee signed into law, oversubscribed, and that's their third school choice programs. So I think it's got to be viewed from the individual, from the parent, not as a system that's trying to replace anything. So it has a piece in the pie. Yeah, every state has to create a public education system. Education clauses require that, but there's a place for school choice. And the clients that we represent are generally low-income people that break their back just to put food on the table. If they have to work a little bit extra to make an extra $1,000 to take their $1,000 education savings account and stretch it, they're more than happy to do it because their kids go to some of the worst schools. I have clients that 94% of the school is below grade level, or there's a lot of violence. Their kid's getting their butt kicked every day, and the parent has to drop them off there and go to work and has no other option, knowing that this is what my kid's suffering every day. There's individual reasons for choice. That's why we know it works. I think on studies, you can look at studies in the first year when there's a transition from the child going from that to a completely different educational option. But there's been a lot of studies. I think there's been over 188 empirical studies on the effectiveness and on outcomes. And I'd say you have to look in the aggregate. What is the big picture? And that's 84% of those are a full 163 positive effect, 10% no visible effect. Okay, 29 studies on the competitive effect of school choice on public schools, 26 of 29 positive effect. Or just go to Florida and spend some time there and see what's happening there. Okay. And so those are kind of some quick bullet points but ultimately it's about the individual child and parent. And that's why we know it's working, because they're choosing it en masse. And that's great.
I just, one caveat, we don't count empirical studies as weight and then kind of say 85% of the studies say something, right? We look at the rigor, we look at the data, we look at even the funding source, where they've double-blind peer-reviewed, and so there is a lot of pseudoscience research out there that is not double-blind peer-reviewed, that is not using the most rigorous quantitative methodologies, and so that's a kind of concerning feature. I watched painfully seeing some of our state senators reference these sorts of pseudoscience reports where, it's kind of like the cigarette companies saying that smoking doesn't cause cancer. Trust me, there's 84 studies that say it. So I do think the studies that have been really rigorous, using multiple years of longitudinal data in states like Indiana, Louisiana, Ohio. Look to Ohio. The Fordham Institute's own researchers come to these conclusions over multiple years about student achievement outcomes. They even write in their own report how frustrated they were to find these particular findings. And so I just want to kind of point that out, that we are moving much closer towards a research consensus that these studies don't improve academic achievement outcomes for the majority of voucher users, while you can find individuals who do benefit from these programs.
Okay, so we're going to shift gears and talk about the constitutionality of school choice programs. Last term, as many of you know, the Supreme Court affirmed by an equally divided court the decision of the Oklahoma Supreme Court. This is the Oklahoma statewide charter school board versus Drummond case. The Oklahoma Supreme Court had excluded a privately run religious school from the state's charter school program. So Ryan, I'll turn it over to you. What can we discern from that argument about the reasons why the court may have ruled that way?
Well, regrettably, very little, because the court wrote no opinion. It simply affirmed. But I think there are some interesting things to be said still about the case itself. And I want to start with by picking up on what the previous conversation left off, which was this concept of how do we introduce innovation into the educational marketplace in a way that accounts for the various needs of children, the various needs of families, that also provides full and complete access. So as much as it pains me to say this as a Texan, our Sooner neighbors to the north are way ahead of us on many of these issues. They've built out what we call a hybrid school choice ecosystem. They do have fully universal school choice in the form of a $7,500 per child, up to $7,500 per child tax credits that allow for traditional school choice like we have in Texas now. They also allow for effectively free transfers between public school districts. They also have a very robust charter school program. And that's where this story picks up, is with the Oklahoma Charter School Program. It's administered by the Oklahoma State Charter School Board. It's something that is considered, all the schools that participate in the charter school program are considered by statute to be public schools. Now, that doesn't necessarily mean they're state-run schools. They're public in the sense that they are freely accessible and open to all. So if you are a charter school in Oklahoma, you can't turn away students. Also, the students do not have to pay to attend these schools. So unlike a voucher system, the school is not going to charge over and above the amount of the voucher or the credit that's going to the school. So in that sense, they really are public schools because they're publicly available to all, but they are formed and operated by private institutions. And in fact, many of these charter schools had popped up over the years in Oklahoma as the program has been run that focus on micro issues. So some of them are focused on STEM or science and technology. Some of them are focused on foreign language immersion. And what happened was the Archdiocese of Oklahoma City and the Diocese of Tulsa decided to get together and build a Catholic virtual school. Now, why a virtual school? Well, the virtual school in Oklahoma is very valuable for a few reasons. One, Oklahoma, as many of you know, is a very rural state. And there are many places in Oklahoma where the only choice available is the local public school. There are no private schools within driving distance for many of those communities. So a private or a charter virtual school was the solution for access for many of these kids in rural parts of Oklahoma. So this school is named St. Isidore of Seville Virtual Catholic Charter School. It applied for admission to the Oklahoma Charter School program. The Charter School Board reviewed the school, reviewed its application, and said, well, this meets all of our requirements. It meets all of the requirements in statute to become a charter school except for one. And the one requirement it failed to meet was a requirement in the charter school statute which aped a requirement in the Oklahoma Constitution that public schools must be, quote, free from sectarian control. And it also ostensibly violated a provision, a Blaine Amendment effectively in the Oklahoma Constitution, which provided that no public funds may go toward the use, benefit, or support of any sectarian institution as such. Now, the then Oklahoma Attorney General, John O'Connor, issued an opinion, an AG opinion, finding that these provisions as applied to the charter school program, and specifically St. Isidore of Seville's application, were unconstitutional in light of Carson versus Macon, Trinity Lutheran, and Espinoza. And so the Charter School Board proceeded to process the application. Now, as that application was in process, there was an election, and a new Attorney General took office, Gittner Drummond, and he rescinded that opinion. And he says, I changed my mind. The office has changed its mind. My office now believes that these provisions are appropriately enforced with respect to charter school statute, and you cannot have a sectarian charter school. Well, the board went ahead and approved the application, relying on the now rescinded opinion, and were immediately sued by the Attorney General. So you ended up with a situation where the state's AG was suing the charter school board appointed by the governor. So, typical in-state fighting. So this goes to the Oklahoma Supreme Court, and the arguments really broke down along a couple of lines, but the lead argument by the Attorney General was the St. Isidore of Seville School was it's a state-funded public school. Therefore, if it's a state-funded public school, you violate both the Oklahoma Establishment Clause as well as the U.S. Constitution's Establishment Clause because it's a religious school. So this violates the Establishment Clause, and therefore it cannot proceed under these terms. So it goes to the U.S. Supreme Court. It grants cert. My colleague Jim Campbell argued at the U.S. Supreme Court, and the oral argument was very interesting because Clarence Thomas's first question out of the gate was, you've got to address this state action question, because the whole case, in his mind, turned on that question. And as the argument progressed, it became very clear that the battle lines were drawn on a couple of different issues. The first issue was simply this: was the degree of control exercised by the statewide charter school board such that it converted what was a Catholic-formed the school, St. Isidore Seville, had a separate board. The board consisted of the Archbishop of Oklahoma City and the Bishop of Tulsa. So there were no state actors on this board. The curriculum of the school was completely designed by the Catholic school. The school did teach Catholic education, but it did not require any students to make a profession of faith or to pass a religious test to enter the school. So it accepted all comers, regardless of their religion. So in that sense, it was a Catholic school that was fully free and open to all students. However, the statewide charter school board did have to govern the school in the sense that it had to meet certain criteria. It had to teach reading, writing, and arithmetic. It had to ensure that it had adequate sanitation, that it had adequate provision of nutrition for low-income students, for all things like that. But they did not dictate the curriculum per se. And so the questions at the U.S. Supreme Court really boiled down to, was that a sufficient degree of control to convert what was a Catholic school into a public school? And I thought it was very interesting because Greg Garr argued on behalf of the state of Oklahoma. And when he was asked, well, tell me, why is it that St. Isidore of Seville is a state-run public school interview when the Catholic Charity in Fulton was not? And he said, well, really it comes down to the fact that it's a school. I mean, that was effectively his answer. He said, it really comes down to the fact that it's a school. And schools are state's business. And we don't need religious schools butting into the state's business when it comes to public education. And he has a couple of interesting and I thought terrifying quotes, one of which I'll read to you. He said, "Court, you've always recognized that the state can't fund an entity to teach religion as truth. That's just simply unacceptable. The state funds can never go to an institution or an entity that actually teaches religion as truth." Now, I don't know about the Catholic Charity in Fulton, but I think that they actually believed what they were teaching. He also said, as this court has itself said, and he pointed to Carson, he said, states may maintain strictly secular public schools. So his argument effectively was this: if you open up the charter school system to religious schools, you're going to be infringing on what is properly a state monopoly on education that's conducted with public money. And that state monopoly must be strictly secular in all of its shapes and forms. So that was the argument. Now, the court obviously split 4-4. Our wonderful guest last night, Amy Coney Barrett, was not on the panel that heard the case. She recused herself. I am very curious to see where this would go, though, if we had a full court.
So yeah, are there any cases in the pipeline that might re-raise this issue?
Not at this time, but I can tell you that I've heard that there's a strong desire to take this case back to the U.S. Supreme Court, and I'm fairly confident that it will find its way back to the U.S. Supreme Court in some shape or fashion, hopefully in a posture that does not require recusals by any of the justices. But I think this is interesting because it points to something that I think Becky's going to talk about next, which is, what do you do with a public school? What do you do with education, public schools, school choice, when a baseline assumption is that public education must be strictly secular and that you can have no teaching of any kind taking place in the public school system that teaches religion as truth? Like, what do you do with that situation? And I think the Mahmoud case is an interesting sort of negative sort of that. It's the flip side of that question. And so I'll be very interested to hear what Becky says about the Mahmoud case.
Well, that's a great segue. So let's move on to Becky. So last term, as many of you know, the Supreme Court issued Mahmoud versus Taylor, its first decision in decades addressing the free exercise rights of parents in the context of public education. Under Mahmoud, Becky, why don't you tell us what parents now need to show in order to opt their children out of the special or specific instruction in public schools?
Thank you, Judge. And first of all, I just want to say thank you to the Federalist Society, to Natalie, to Arif. I know to so many others for all the hard work to put this weekend together. I know it's a huge amount of labor and late nights. I'm grateful for that. I'm grateful to be here. I want to offer just a quick word of background about the Mahmoud case, and then a couple of thoughts about how I think it intersects with our discussion here this morning. So Mahmoud is a case that comes out of Montgomery County, Maryland, where back in 2022, the school board announces a new series of inclusive storybooks for elementary-aged school children. Those books are selected specifically by the board's own admission to disrupt cis-normativity and either-or thinking on gender and sexuality. So, for example, one picture book directed at pre-kindergarten follows a puppy through a pride parade and invites children as young as 3 or 4 to identify in the book images of underwear and leather and a drag queen. Another book, also for elementary school, tells children that at any point in our lives, we can choose to identify with one gender, multiple genders, or no gender. It then asks children to ponder what pronouns fit you best. In the guidance document, teachers are actually told to instruct students that when we're born, people guess about our gender based upon our sex, based on our body parts. And sometimes they're right and sometimes they're wrong. And if a child were to express disagreement with the idea that a boy can become a girl, teachers are then told to instruct the child that those comments are hurtful. Now, the board, after rolling out this new storybook curriculum, initially tells concerned parents that it will honor its pre-existing policy, notifying them when the storybooks were to be read and allowing them to opt their children out of that specific instruction. That continues for a number of months. Then, in March of 2023, the board flips on a dime. Literally one day, it reaffirms its commitment to the existing opt-out policy. The next day, without explanation, it says, no more notice, no more opt-outs, only for the Pride storybooks. So you can continue to opt out of sex ed in high school, but no opting out of Pride Puppy in kindergarten. Now, as it turns out, Montgomery County is the most religiously diverse county in the country. It has a huge population of Muslims, of Christians, of Jews, many other religions, and there's a huge community outcry. Hundreds of parents show up at school board meetings to advocate for the restoration of the opt-outs, and at those board meetings, they are accused of espousing dogma and aligning themselves with white supremacists and xenophobes because of their objections. So Beckett then files a lawsuit on behalf of a diverse coalition of religious parents, each of whom has a sincere religious obligation to direct the religious upbringing of their children, specifically on matters of sexuality and gender, and to protect their children from instruction that would undermine those core religious beliefs. So the core question in the case, and the reason I think it's relevant here this morning, the core question becomes, are those parents' rights to direct the religious upbringing of their children substantially burdened by the board's denial of the opt-outs for these storybooks? In other words, can you make out the first step of a First Amendment claim when the board seeks to instruct your young children that doctors guess about whether you're a boy or a girl when you're born? And the answer in the lower courts is no. There is no substantial burden. And specifically in the Fourth Circuit, the basic reasoning is that unless you have proof that you, the parents, were compelled to change your beliefs or your conduct, then there's no First Amendment burden. And so there's no way from a constitutional perspective to affect the opt-out policy that you're seeking here. The court grants cert. My colleague Eric Baxter argued the case this last term, and then it reverses 6-3 in an opinion by Justice Alito. The key holding of the case and the standard that now applies in this context is that parents' rights to direct the religious upbringing of their children are violated by government policies that substantially interfere with the religious development of their children. So substantial interference is now the key standard. Couple key doctrinal points about the opinion. I know we're running short on time. First of all, I think one of the most significant aspects of the court's opinion is its treatment of Yoder. Yoder's a 1972 decision holding that the Amish could not be constitutionally compelled to send their children to public school past the 8th grade. For decades, lower courts had basically dismissed Yoder as an Amish one-off case. The attitude was really, we don't have to think very hard about Yoder because you're not Amish. And the court rejects that. It draws the substantial interference standard directly from Yoder and says, look, we've never cabined Yoder to its facts. And so the court really embraces and, in my view, restores Yoder to its proper place as a lodestar in the free exercise canon. The second move I think the court makes, which is really important here, is that it also rejects Bowen as the paradigm. The rule the board wanted, going to Ryan's comment earlier, the rule the board wanted here was that running the public school system is just like the government conducting its own internal affairs. It was basically the Greg Garr line from oral argument at Drummond. So, effectively, running the public schools is like the government selecting its filing cabinets, and the government can't be expected to select its own filing cabinets in a way that comports with the religious beliefs of all of its citizens. That's just not administrable. The court, again, says no. Running the public school system is not like administering Social Security. It's not like selecting a filing cabinet. It involves direct coercive interaction between the state and young children. And so I think the forceful rejection of that paradigm is really important for the parental rights discussion generally, and for the future of parental rights in the public schools.
What does Mahmoud mean for parents who are not religious? Can they cite that for similar claims that are not based on religious rights?
Yeah, so it's a great question. That the core holding of Mahmoud is a free exercise holding. But the point I'd make there is that, as a historical matter, religious liberty is a catalyst for a host of other liberties. You see this in the original development of free speech. Religious speech comes first. A host of other protections for other speech comes later. The same is true of freedom of assembly. Josh McDaniel actually has a really fascinating new article out about I think it's the Washington University Law Review, where he makes this argument about key cases involving the Jehovah's Witness in the early 20th century and traces their litigation to the development of broader secular rights. So short version, Judge, I would say that the core holding of Mahmoud is a free exercise holding, but my own prediction here is that parental rights for religious parents is going to lead to parental rights for all parents. And specifically here as a practical matter, I really don't think school districts are going to be able or feel able to roll out an opt-out system that only allows religious parents to object while denying those same opt-outs to parents who have secular or philosophical objections to the same content. So I think here that the headwinds are really sort of in the practical application, that when a school district is complying with Mahmoud, not all school districts are, by the way, but when they are in good faith trying to comply with Mahmoud, I think all parents benefit.
Yeah, go ahead, Ron.
I want to add some things. I think Becky made a really important point, and I don't want that to be lost on the audience. There was something that was said in the opinion in Mahmoud that I think is easy to gloss over, but is incredibly important. In the majority opinion, Justice Alito he writes that these books that you were talking about, they are this is quoting from the opinion, unmistakably normative. He said they are clearly designed to present certain values and beliefs as things to be celebrated, and certain contrary values and beliefs as things to be rejected. So right there, he's pointing out that the role of the school is to inculcate normative values, and you can't escape that fact. This whole idea that Greg Garr propounded at oral argument that, they just have to be purely secular, i.e. neutral, is hogwash. It's completely false and impossible to implement. Of course schools are inculcating normative values. The question is whose and how are you going to deal with and how are you going to treat those who object? And I think in the Mahmoud case, it was very interesting to me what the relief was. The relief was, okay, we're going to exclude these books from the public school. It was, we're going to let parents have notification and opt-out rights. But those books are still there, right? And so the question becomes, as you said, Judge, if you are not someone of religious faith, if you're someone who has a secular objection to content, well, what does that mean for if his public school were to voluntarily bring religious content, normative content, value inculcating content into the classroom? And I asked that question in light of Kennedy. Because in Kennedy, obviously, the Lemon test is gone. We're now interpreting the Establishment Clause in light of history and tradition. And if you're interpreting the Establishment Clause in light of history and tradition, as Professor Barclay at Notre Dame has said, you're really looking at the coercion test. Well, this was a case about coercion. We're coercing parents who disagree with this content, but we're coercing their kids to sit through it, and by extension, coercing their parental rights. Well, what if the shoe's on the other foot? What if we are placing religious content in public schools, allowing for notification and opt-out? How is that any different? But apparently, according to the state of Oklahoma, the correct answer there is to exclude the content entirely. We're not going to give notification and opt-out rights. We're just going to kick the content out of the classroom entirely because it's religious. I think that's a very interesting dichotomy. And so, I mean, to me, that is one of the lessons from Mahmoud is, yes, there's a moral valence was taught in the classroom, but we treat these things differently when they have religious versus non-religious content.
Thank you. Okay, so this year marks the 100th anniversary of the United States Supreme Court's decision in Pierce versus Society of Sisters. Many consider Pierce to be a cornerstone in the legal defense of parental rights and the right of parents to direct their child's education. So let me ask you, Arif, how does Pierce apply to these choice issues we've discussed today?
Pierce turned 100 years old, and it's really important. One of the reasons it's important is because the third big thing that happened in the school choice world nationally is that SCOTUS, you talk about Blaine amendments, neutered the Blaine amendments intentionally in Espinosa v. Montana and in Carson v. Macon. Programs that allow parents to pick a religious school can exclude those schools without violating free exercise. What that led to is a lot of litigation, primarily under education clauses, where the unions want the clause to not just mandate a public ed system, but impose a ceiling on legislatures' plenary power to do anything else, monopolize public ed. Now, Pierce, the effect of that, if it takes hold, and it hasn't yet, but it's happening in our cases, is that an entire class of people that just want to pick religious schools, which Pierce stands for the proposition that's a fundamental right. That's a, quote, the child is not the mere creature of the state. Those who nurture him and direct his destiny have the right, coupled with the high duty, to recognize and prepare him for additional obligations, period, end quote. That's Pierce. You're basically saying that if you want a private school, you're out. The state can never help you. And now Pierce, that tees up Pierce and the 14th Amendment. And so Pierce is important for that reason. And a lot of what's happening now in the wake of all this innovation is there's, of course, many choice programs, but there's a lot of innovation. So all the types of micro schools and co-ops and all sorts of educational options that are coming online are also facing headwinds. And that's where the next battles are going to be. Are they going to be facing zoning codes, fire codes, any kind of exertion of restrictions on their ability to innovate? You're taking old stuff, old regulatory schemes, applying it to innovative things. There's a mismatch. Pierce can do a lot of good there. So I think that turn 100 years old, it's a case about the state of Oregon trying to force everyone into public school. There was a compulsory attendance law, and in Oregon they decided to eliminate the exception for public education, for private schooling. So you had to go to a public school. And SCOTUS put an end to that in Pierce. And we haven't heard the last of Pierce. And I think it'll play a more prominent role as educational options become more decentralized and more options come online.
And Becky, what role did Pierce play in Mahmoud, if any?
So, Judge, this is where, in the interest of candor, I have to offer the disclaimer solely in my personal capacity that as a former Thomas clerk, I develop an involuntary twitch when I hear the words substantive due process or cases that rely on the same. And then I hear the CT laugh track in my head, which is what's playing right now. Here's what I would say about Pierce. Arif is completely correct as a descriptive matter about the seminal place of Pierce in the parental rights canon. Pierce was also decided before the free exercise clause was incorporated against the states. And in Yoder, Yoder relies heavily on Pierce in recognizing the primary role of parents in directing the religious upbringing of their children. So in Mahmoud, CT writes a separate concurrence that I think makes pretty clear that he views Pierce through the lens of the free exercise clause. There is one citation to Pierce in the majority opinion that I think suggests the majority is hinting in the same direction. But I agree with Arif that we haven't seen the last of Pierce. It will continue to play a role in the next wave of parental rights litigation. And I think it's an open question whether when Pierce comes back to the court the next time, the court will continue to view it primarily as a free exercise clause case. Maybe that by then someone will write the seminal law review article on the privileges and immunities version that should have been written in the first place.
Okay. David, let me ask you, some public school districts, including apparently here in Austin, have begun allowing parental choice within the district so that families can enroll their children in a public school that's not necessarily the one they're assigned to. So if you would address that issue and how parents have responded to these greater options within the public school or within the school districts.
Sure. So this is a national trend. There's always been some degree of choice in big cities. So New York City has these elite public high schools. There's been magnet programs, but now we're seeing a kind of a ramping up of that where within big cities like New York, LA, Austin, open enrollment magnet programs are giving families a lot more options. Sometimes they're oriented around like dual language programs, so you want your children to learn in 2 languages or even 3 languages in some public schools. And there is some pretty strong support for these options among parents in the kind of survey research that I've seen to be able to kind of pick and choose these certain program options that might better fit your child. Early college high schools in Texas is a really big reform where kids can get community college credit while they're in high school. That's often a choice program within school districts that I see as really popular. And so I think parents do tend to like this, especially as they get to high school, because parents can get access to certain specialized programs or programs that kind of start to fit what children, youth are really thinking about for their career pathways or college. There are some issues with it. There's perceptions of where the school is. If it's in neighborhood X versus neighborhood Y, is it a good school? Is it a bad school? We see some districts have not had enough kind of checks and balances in place to make sure that there's not discrimination in the admissions process if there are certain admissions requirements. So the same thing I was talking about with private schools being able to choose, and maybe that's not a kind of a free market for kids to kind of easily enter into that market. Well, we see that in public school choice programs. Some magnets apply certain standards, even sometimes when they say that they're not, they still end up applying certain standards. And so we see positive outcomes in a lot of these models, but we also see some forms of discrimination that I think really requires school boards and states to kind of think a little bit more carefully about how you design these programs, how you set parameters. But I do think there's opportunities here to increase student engagement, to kind of raise parent satisfaction. Parents generally are very happy with their public schools. When you look at longitudinal Gallup surveys, the public has seen a pretty sharp decline over the last 20 years, 10 years in support for public ed. But parents sending their kids to the schools, they kind of hold steady and with a high level of support. But I do think these sorts of programs kind of build on that. I think there are some risks, though, around kind of segregation. A lot of times, because of transportation costs, kids are kind of still trapped in certain neighborhoods. Parents in more affluent parts of a city like Austin aren't, applying to some of the schools that might be in East Austin that are less affluent, serve more students of color, and in some cases, it can create even greater segregation. And so I think there's some success stories. I think there's lots of avenues and opportunities for expanding choice, but I think, like anything, it's nuanced, it's complex, it requires careful design and study, and I think that's the kind of area of focus if you're a state, if you're a district interested in doing this or already doing it, the careful planning, the appreciation of complexity, and making sure that you're not disadvantaging certain communities, different student groups, different schools when you design these programs.
Okay, thank you. So we have about 7 or 8 minutes left. If anybody in the audience has a question, we got some people lining up here. Okay, we'll go ahead and start with you.
There was a talk about the paucity of private schools in Texas. Mr. Banger talked about charter schools, which we have. My question was about homeschooling. What does the data from other states show about educational savings accounts and their effect on the growth of homeschooling and the outcomes of those students? Thank you.
David, have you studied that or know about it?
I'm curious what Arif knows. Homeschooling is kind of an area that I've not focused in a ton, but I do know homeschooling has been a growing kind of area for more than the past decade now. In SB2, parents are not who are homeschooling. They're not eligible for the full $10,000. I think they're eligible for about $2,000. Different states have different requirements in terms of what are the expectations, but it is certainly something that is growing. The extent to which folks are measuring it and what you're measuring, I think, is somewhat a state-by-state issue.
Yeah, I think one state that would be good to look at is Utah. The Utah Fits All Scholarship Program was wildly popular with homeschool parents, and many homeschool families subscribe to it, including some of our clients. And there you're able to use the full amount in the first year. I think that was attractive because the parents were building just great menus of options around what their kids were doing at home. But generally, school choice programs will give a little bit less. And in Utah, they actually ratcheted it down because homeschool parents were embracing this, and a lot of people were on waiting lists. We'll have to see. Ed Choice, Milton Friedman's legacy, or Milton and Rose Friedman, the Friedman Foundation became Ed Choice. Does a lot of study. And so off the top of my head, I'm not sure if they've looked at homeschooling specifically. But the reception in the Texas legislature was positive. There's always some skepticism from homeschool families. They want the government out, and that's a healthy skepticism. But they understand that there are safeguards in the statutes, and it's a voluntary program, and it doesn't come with strings attached. And we've seen that across the country, that homeschoolers have been happy participating in programs. So Texas is going to be one of those where we expect many homeschool families to participate.
Okay. Sir?
I just want to thank the panel, and my question's primarily directed to Professor DeMatthews. If we look around the country, we've seen education spending is at an all-time high. Districts across the country, such as Baltimore, Detroit, Chicago, have student spending for their public schools in the $20,000, $30,000, $40,000 ranges per student every year. But we see that all these districts are at all-time lows in terms of proficiency in math and reading, with some schools having no students be proficient in math and reading. Why do you think directing more money to these public schools who don't seem to be advancing and preparing our students to be proficient in core subjects is a better use of taxpayer funds than allowing more options for parents to send their students?
Sure. Thank you for the question. So a few things there. I was a teacher in Baltimore City Public Schools, and I think if you're a parent, you'll probably agree with this, that while researchers know the number one variable in a school that predicts student achievement outcomes is the quality teacher, the most important factor is that child's family, the neighborhood in which they live. And if you've worked in a place like Baltimore where there is historic disinvestment, high rates of community violence, police violence, rare access to high quality health care. There are a lot of things that Baltimore City schools are being asked to work with in the first place. Second, in a lot of these cities, there has been significant declining enrollment. And so the amount per pupil will go up as schools become under-enrolled. And so it may look like there are big investments into Baltimore City public schools, but there really isn't, and year after year, there are persistent cuts. And so I'm not here to defend the public education system. I think there's lots of problems with it. I think there's a need to engage in serious reform, especially around teacher quality, especially around making sure that if no one else is going to do it, if the legislature is not going to do it, if businesses are not going to do it, if kids need access to mental health care, food, nutrition, that schools end up stepping into those roles far too often. That should not be the case. When I was a teacher, when I was an administrator, buying socks and jackets and driving kids to child family services, and that gets in the way of instruction, but kids are not going to learn and be successful in that sort of environment. And so I think we have to take care of, as a society, we have to better take care of children who are vulnerable, especially living in those communities. And then the last thing I just would say, we are seeing some really negative results on NAEP. This is a very kind of politicized issue. given kind of COVID policies and how, schools were closed, reopened. But I would say it's very, very clear that COVID had a pretty significant impact on students' achievement, their well-being. And I think we're continuing to see that. We thought early on that investing into tutoring was going to help. But like with any program, as these tutoring programs went to scale, they didn't have the same outcomes that they did when they were kind of smaller programs. And so we do have a lot of issues around academic achievement. I just don't see, though, the evidence in the large voucher programs that academic achievement is going to be raised, and especially not for the kids that I worked with in Baltimore and DC who did not have the means to go to Gonzaga High School, and that a small voucher of $10,000 like what's offered here wouldn't even get you in the door.
Okay, I think we have time for one last question. We've got about 2 minutes.
Thanks. My name is Alan Parker. I'm president of the Justice Foundation. We litigated for school choice in Texas, and I was on the open enrollment charter school evaluation committee. So just 2 quick questions. In San Antonio, one of the public school districts, responding to the competitive pressure of SB2, has said, we will take students from outside our district, and you can come to our public school and get educated under this fund. Do you think that's a positive development? And then the second thing is, in Texas, 40% of Texas 8th graders scored below the basic reading level, which is extremely low, as you know. Not very many made proficient, which is what we'd like the majority of students to be. What do you think is are you glad a public school is endorsing the program by responding to competitive pressure and accepting students from another district? And then what's the major problem for less than 50% of the students being able to really read well in Texas?
So it sounds like a question for David. You have 1 minute.
Okay, sorry. So
You got to answer all that in 1 minute.
I think in the long term, there needs to be more research on how like choice programs where districts kind of are competing for kids and how that plays out. But again, there are these violations, I think, of free markets when we get into these sorts of choice programs. In terms of reading levels, again, so it's not magic, mysterious forces of a market that helps kids learn to read. It's a well-trained teacher, and that's whether it's in a private school, whether it's in a charter school, whether it's in a traditional public school. That's what explains whether or not a child reads, and if it's a struggling learner, whether that child gets what they need. And so our state is in a crisis right now because of funding issues, attacks on teachers. About 30% of teachers last year that were hired were entirely untrained and uncertified. And so we're in a crisis where our eye's not on the ball. All of us, whether we care about choice, vouchers, public schools only, whatever it is, we need to care about teachers and getting high quality teachers into classrooms wherever they are.
Okay, Arif has an announcement about lunch.
Yeah, lunch is next. And then
Here.
lunch is next, and we'll have a panel. The food's not in here, but I think we'll go out and take a break, and we're proceeding to lunch.
Okay, well, join me in thanking our panel, and we'll see you at lunch.